Hello CLAT PG aspirants, welcome to Vidigya After College. As you would be knowing that if you are preparing for CLAT PG, you should be having the knowledge of recent Supreme Court cases. So in this series, we would be discussing the most relevant recent cases of Supreme Court of 2026. Starting with the first case. The case which we are going to discuss today is the state of UP versus Anurudh. This is a division bench case where the matter is with respect to the POSCO Act and the victim's age. If suppose there is a case where a person has been accused, A is accused of offences which includes IPC or BNS, and with this the person is also accused for the protection of children from sexual offences cases. Okay. So if the person is accused of these cases, so now if the matter is before the trial court, now the person was accused of POSCO case also. So if the POSCO is involved, that means the victim should be below 18 years. The victim should be child. So the matter was before the trial court and the person applied for bail. Okay, if suppose the person has been accused, he has been arrested, he has been in custody, so before the trial court he would be applying for bail. So the person applied for bail with respect to these cases and the trial court rejected his application. Now the matter went before the High Court. The person applied for bail before the High Court. Now the matter or the question before the High Court was whether the accused should be granted bail. And now at this bail proceedings, whether the question that the victim is of 18 years or not should be decided or not. Here the question before the High Court, which the High Court decided that yes, the matter should be decided. Yes, the question with respect to the age of victim. Why we are discussing the age of victim? Because we are saying that if the Protection of Children from Sexual Offences Act is involved, the victim should be of below 18 years. So if we are discussing the matter with respect to POSCO, so the victim should be of below 18 years. And if the matter is with respect to the bail of an accused, under this cases, it should be decided or it should be discussed that the victim is below 18 years. So here the High Court decided or gave the direction that during the investigation, what is investigation? The police would be doing investigation. After that, the trial would be commencing. So we are saying that during the investigation or before the investigation itself, the police officer should conduct medical examination with respect to the age of victim. So the High Court gave the direction during the bail proceedings. The matter was before the High Court to decide the bail application. In this bail proceedings, High Court gave the direction that the police officer in every case which involves POSCO, at the starting of investigation, they are mandated to do the medical examination of the victim to decide whether she is below the age of 18 or not. So this was held by the High Court. Now the matter went to the Supreme Court कि the direction given by High Court in bail proceeding is correct or not. Here the question is whether the directions wherein the High Court has mandated the police officer to conduct medical examination to decide the age of victim is correct or not, कि ये direction सही है या नहीं. So this was the question before the Supreme Court, and now we would be discussing what the facts and what are the issues and what was held by the Supreme Court. So if we discuss the facts, respondent number 1 is accused of having committed offences under this of IPC. So IPC offences were involved. Along with that, section 7 and 8 of Protection of Children from Sexual Offences was also involved. Now in the FIR lodged at the instance of mother of the victim. So the mother of victim stated that the victim is of age 12 years. Therefore, she also asked for the application of POSCO. had been abducted from her home, the trial court rejected bail by order this. So the accused asked for bail before the trial court. The trial court rejected the bail application. Now, in the proceeding for bail before the High Court, now the proceeding with respect to the bail is going on, and in this the matter was there. The chief medical officer. So when the proceedings of bail were going on, the High Court directed the medical officer, the chief medical officer was directed to constitute a medical board for the determination of age of the victim. So the High Court, while hearing the bail proceeding, directed that a medical board should be constituted to determine the age of the victim. The court then released the accused on interim bail, observing that there was wide inconsistency in the age of victim as in the school records. So during the bail proceedings only, they discussed or they determined this question whether the victim is of below 18 years or not. So while discussing this or while deciding this, they took the evidence also. They saw the records also, the school records. Suppose the 10th mark sheet shows that what is your date of birth. So this records were seen by the High Court. On the basis of this, they decided that, or they determined that there is certain inconsistencies. The record is saying something, the confession or the statements, the stated as stated by her in the statement under 161 or 164 of CRPC regarding age or intimacy with the accused, among other factors. So there were certain inconsistency with respect to age of the victim. So the records were saying something, the statement of the victim was some other statement. So here, because of this inconsistency, the accused was granted the bail. In assessing the age of the victim, High Court evaluated prior precedents of the High Court, which collectively prescribes that medical determination of age under this sections is mandatory and is often a more reliable indicator than the documentary entries. So here the High Court stated that if you are asked to determine the age, suppose if the court has to determine the age of the victim, what is the most reliable option? So the most reliable option would be medical examination rather than the documents. Okay. Next, it concluded that section 164A CRPC and 27 of POSCO obliges police to obtain victims' medical age report at the commencement of investigation. The High Court noted recurring systematic lapses wherein the police failed to obtain medical age reports. Trial court ignored scientifically assessed age and consensual adolescence relationship. So here the High Court stated that the lower court, that is trial court, has not seen the medical reports, has not conducted the medical reports, and they focus more on the records like the school certificate, like the 10th mark sheet on which the date of birth of the person is mentioned. So here the High Court directed something. As we were saying, the High Court gave certain direction while hearing the bail proceedings. So what directions have been laid down by the High Court? So here the High Court stated that the investigation officer shall ensure that the medical report determining the age of victim is drawn up by the competent medical authority at the commencement of investigation of POSCO. If the case involves a POSCO offense, therefore if the case involves a POSCO offense, the investigating officer, the police officer, at the commencement of the investigation only has to conduct medical examination of this person to determine the age. Okay. Next, the medical report of victim determining her age shall be produced by the police officer before the court hearing the bail application. So if the matter comes before the court for bail also, then also this medical report has to be shared with the court. Next, the court hearing the bail application has to accord full weight to the medical age determination report of the victim and also carefully examine all other documents relating to victim's age. So here the court, High Court, is directing that if a trial court, if any other court is is deciding a bail application, in deciding this bail application, they also have to see the medical age of the victim, and they also have to consider all other documents. So here at the stage of bail proceeding only, you are discussing what? You are discussing the evidences. So this was questionable before the Supreme Court. The age determined by the competent medical authority under section 164A of CRPC, read with section 27 of POSCO Act, can prevail over other age related documents. So like school records, as we were discussing, if 10th mark sheet has the date of birth, so here the High Court has stated that this 10th mark sheet should not be considered, and which should be considered, or which document should be given preference. So they are saying that the medical report should be given the preference. The High Court, while exercising bail jurisdiction, issued the direction. One of the issues raised by the appellant state is that the same was beyond the scope of jurisdiction. So now the matter is before the Supreme Court. This was the direction of High Court, and now against this direction, against this matter, the matter is before the High Court. Now matter is before Supreme Court. So before the Supreme Court, the first question would be here the High Court was not competent during the bail proceedings, because this during the bail proceedings you only have the power of, as given by the statute, as given by CRPC or by BNSS, you only have the power with respect to bail determination. You cannot give certain directions with respect to overall proceedings. So the question or the arguments by the state is that the same was beyond the scope of jurisdiction of the High Court. The question of jurisdiction to issue these directions also confronted the learned single judge. So the matter was also raised before the High Court also. When the High Court was giving this direction, before this the matter was raised before the High Court itself, that you don't have the jurisdiction to give this direction. So the High Court, the single judge of High Court, stated that he has direction, who answered the same, stating that while exercising the statutory jurisdiction, because the CRPC or BNSS provide with respect to bail, so while discussing or while deciding or while exercising the statutory jurisdiction, the High Court is not denuded of its constitutional status. So the High Court stated that even if I am discussing, even if I am deciding a bail application as provided under a statutory provision, the constitutional powers have not been removed from me. I still have constitutional power, and therefore I can use these powers. So these were the statement of High Court. The High Court is a court of record and constitutional record, irrespective of the nomenclature of jurisdiction. Even if I am discussing, even if I am deciding bail application, still I am a constitutional court, still I am a court of record. Therefore I cannot be said that I don't have the jurisdiction. This was the statements of High Court. While deciding the bail application, the High Court exercises a composite jurisdiction of statutory power and constitutional obligation. So they are saying that whenever a statutory power has been exercised by the High Court, at that moment also they are the constitutional body, they are the constitutional courts, therefore they can also use that powers. The High Court always possesses the necessary power to decide such issues for dispensing fair justice and to realize the fundamental rights of an accused in bail jurisdiction. Refusal to decide the said issues would amount to abdication of constitutional obligations of this court. So this was the ruling of High Court, how they justified giving this direction in bail proceedings. Okay? But the issue before the Supreme Court was, we are saying that the High Court has given certain direction, and they are saying that the High Court is empowered to give this direction because this is a constitutional body, this is also a court of record, therefore they can give certain direction. Now the matter went before the Supreme Court, and the issue before the Supreme Court was, the question presented in this appeal, however, is not one of relative ease as an appeal against the grant of bail, and instead hinges on the scope of section 439 of the CRPC, because section 439 of CRPC provides with respect to bail, the the bail application can be made before the trial court or before the sessions court. So sessions court or before the high court. So this has been provided under section 439. Now the same provision has been provided under BNS, and the question for you is to know ki to say, make a comment with respect to what is the provision under BNSS with respect to bail, wherein you can apply for bail before the high court or sessions court. Okay, so the same provision has been included in BNSS also. Now the question before the Supreme Court is not with respect to the appeal of bail. They are not simply deciding the bail application. No, here the main question was, can the High Court give this direction under section 439 of CRPC? In the High Court's own record or own word, the question of law which arises for consideration in this bail application is the nature of legal duty cast on the police to draw up medical report determining the age of victim while investigating POSCO Acts offences. So here the High Court direction that you should be doing medical examination of the victim to decide her age at the starting of the investigation. So this direction is the point of contention. The jurisdiction of this court to determine this question will predate the discussion on the merits of the bail. So here the question is whether it is coming within the jurisdiction of High Court or not to give this direction, or ye karna chahiye ki nahi. The jurisdiction of this court to determine this question will predate. So the Supreme Court would be first discussing whether the High Court is empowered to give this direction or not, and then they would be deciding with respect to bail. The question that the Supreme Court is called upon to consider is whether section 439 CRPC, the High Court could have issued direction mandating age determination tests to be conducted in all cases involving POSCO. So here now we are discussing ki the age of victim should be decided. So how the age of victim should be decided? Is there any provision with respect to this? So section 27 of POSCO states that medical examination of a child, the medical examination of a child should be conducted. Suppose a victim is there, or suppose a person is there who has been sexually abused, he or she has been sexually harassed. So with respect to this, certain medical examination has to be conducted. So it is provided in section 27. So medical examination of a child in respect of whom any offense has been committed under this act shall, notwithstanding the first information report or complaint has not been registered for the offenses under this act, be conducted in accordance with section 164A of the CRPC, which is same as section 184 of BNSS. 184 of BNSS provide for medical examination of rape victims. Here we are saying that if the offense is with respect to POSCO, so victim of POSCO offenses would also be medically examined under this section. Now in the case of victim is a girl, so the medical examination would be conducted by a woman doctor, and the same. So suppose this same provision which is provided in 184 with respect to victims of rape would be applicable if the victim is of a POSCO offense. Now we are saying that POSCO offense ke respect mein the victim would be medically examined under section 27, but this is the provision with respect to 184 of the CRPC which provides for medical examination of a victim of rape. Under section 27 of POSCO, we are saying that the victim of POSCO would be medically examined as per 164A of CRPC, that is same of 184 of BNSS. Next, here suppose we are saying the age should be determined. Is there any provision with respect to age determination? We discussed that there can be medical examination. In this medical examination, the medical officer would be discussing ki what are the marks on the body of the victim, what is his mental status, he would be mentioning the age. But here there is no procedure laid down ki how this age would be determined. See, if you see this 184 section, the registered medical practitioner to whom such of woman is sent shall without delay examine her and prepare a report of his examination giving the following particulars, namely the name and address of the woman, and of the person by whom she was brought, the age of woman. So here it is provided that the medical report would be expressing what is the age of the woman, but here how this age has to be determined has not been provided. What is the procedure to be followed by the medical officer to determine this age of the victim? He can simply she can simply ask what is the age of your what is your age, and if she's saying that her age is suppose 14 years, so she would be reporting this in the medical report. The description of material taken from her person for DNA profiling, suppose sexual offenses are there, and for that DNA profiling has to be done, so what sample she has taken, that has to be mentioned in the medical report. So here the question is with respect to the age of the woman. There is no procedure laid down ki how this age of the victim would be decided. Under juvenile justice act, we see a provision with respect to how the age of child in conflict with law, or child who has requirement with respect to care and protection. So with respect to that, we have a provision. See, section 94 of Juvenile Justice Act provides where it is obvious to the committee or the board ki there would be juvenile justice board or the child welfare committee. So if a person is before the board or the committee, and now the question is with respect to age of such person who can be a child with conflict with law or child which requires care and protection, based on appearance of the person brought before it under the provision of this act, other than the purpose for giving evidence that the said person is a child, the committee or the board shall record such observation. Ki suppose a person is before the committee or the board, and now the board or the committee is not sure what is the age of this person. So here on the simple appearances, if they are understanding that the child can be that the person can be a child, they would be recording this. The committee or child shall record such observations stating the age of the child as nearly as may be, and proceed with the inquiry under section 14 or 36 as the case may be, without waiting for further confirmation of the age. Suppose the child is looking of 10 years, so I would be recording that and proceeding with the inquiry. But in case the committee or the board has reasonable ground for doubt regarding whether the person brought before it is a child or not. Suppose we can see that child is of 5 years because it is obviously visible that the child is of 5 years. But suppose the child is of a particular age from the ranging from 16 to 18 or 15 to 18. In this age, we won't be able to gauge what is the age of this person. It can be doubtful whether he is below 18 or he has crossed 18 years of age. So if this is the case, as the case may be, shall undertake the process of age determination by seeking evidence by obtaining. So if there is a doubt with respect to the age of such person, you would be determining what is the age of this person by the date of birth certificate from school or matriculation or equivalent certificate. So here if there is a doubt, the first thing you would be checking is his or her matriculation or equivalent certificate. 10th mark sheet would be seen what is the date of birth mentioned on this mark sheet, which has to be provided by the school. Next, if available and in the absence thereof, so the first priority for determination of age of such person would be given to the document, would be given to the certificate given by the school. If it is not present, then the birth certificate given by a corporation or municipal authority or a panchayat. Birth certificate as given by the municipal corporation or the committee would be seen. First preference would be given to the certificate of school. Next, if this is not there, we would be seeing the birth certificate issued by the municipal corporation. If suppose, and only in the absence of 1 and 2, if you don't have the 10th mark sheet, you don't have the birth certificate, then medical examination would be conducted. Age shall be determined by ossification test or any other latest medical age determination test conducted on the orders of committee or board. So this is with respect to age determination of a person who is before the committee or before the board. So who are coming before the committee or board? That can be child in conflict with law. What is What does child in conflict with law means? Child in conflict with law means the person or the accused, when the accused is under the age of 18, means the accused is a child, that would be child in conflict with law. What is child which requires care and protection? That can be a person, that can be a child who has been abandoned, that can be a child who has been surrendered, that can be a child who has been abused, or that can be a child who is found begging on the streets. So all those all this child would be considered child in requirement of care and protection, child in the need of care and protection. So this is the age determination test, age determination sequence provided under Juvenile Justice Act, and this is majorly used for accused person. The age recorded by the committee or board to be the age of person. So this is the test laid down under Juvenile Justice Act. Now the question again come with respect to age determination of the victim. Here we did not find age determination test for the victim, but what is the court's analysis with respect to this upon the question of jurisdiction? So right now we have discussed the legal provisions. We have discussed there is medical examination under section 27 of the POSCO Act. It was provided that the victim would be medically examined, and in this medical examination report a mention of age would be there. Now there is no procedure laid down with respect to age determination under POSCO or under CRPC or BNSS. When we see the Section 94 of Juvenile Justice Act, there we find a procedure to determine the age, where we can say that if you have to determine the age of a child in conflict with law or a child in need of care and protection, you can follow the procedure that you can first see the 10th mark sheet. You can then, if this is not present, you can see the birth certificate issued by the municipal corporation, and if both the things are not there, then you can go for medical examination for age determination. So first thing which is decided by the Supreme Court is with respect to the jurisdiction. If you are saying the High Court has given the direction while discussing the bail application, does the High Court have this jurisdiction or not? So the question was upon the question of jurisdiction to issue direction by High Court while exercising bail jurisdiction. So the court's jurisdiction, that is either the Court of Session or the High Court under section 439 is limited to adjudicating the question of person concerned being released into society pending trial, or whether they should continue to be incarcerated. So here we are saying that if the High Court or if the Session Court has been if the Session Court or the High Court is deciding the bail application, this simply has to decide the question of bail. It is unquestionable that High Court is constitutional court. However, in the instant case, the error of jurisdiction by the High Court was in the exercise of statutory power and not under the Constitution. The Supreme Court stated that we know or we understand it is unquestionable that High Court is a constitutional court, but that does not mean you would be including the constitutional powers while exercising statutory powers. So while deciding bail application, you are discussing or you are using the statutory powers under section 439 of CRPC. So here, while using this or while exercising your statutory power, you cannot inculcate constitution. The power arising from the constitution and those flowing from a statute are distinct and separate. So here the Supreme Court differentiated between the constitutional powers and the statutory power. So the constitutional powers are different from statutory power, and you cannot overlap them. The essential distinction between these two species of power lies not merely in their origin, but also in their constitutional status and susceptibility to control. Constitutional powers are sovereign, foundational, and insulated from vicissitudes of ordinary legislation. They can neither be curtailed nor expanded by parliamentary enactment. So the constitutional powers cannot be curtailed or enlarged by the statutory powers. Statutory power, on the other hand, by contrast, are subordinate and mutable and existing at the pleasure of legislature. Statutory power would be as provided in the legislature. If the law is giving you this power, then it can be said that you have such powers. You cannot overstep from the legislature or the law, which may at any time amend, restrict or repeal them through the ordinary legislative process. The constitutional power cannot overshadow the statutory power, enlarging its scope. So by using constitutional power, you cannot overreach your statutory powers, its scope, enlarging its scope beyond what has been envisioned by the statute. In other words, while both powers rest with High Court, one power cannot usurp the ambit of another. By saying that being a constitutional court, you cannot say that you can use this constitutional power while deciding the matter which is limited under a statute. So while deciding a statutory jurisdiction, or while deciding a statutory power, you cannot use the constitutional power to enlarge the ambit of statutory powers unless otherwise permitted by the law. On the aspect of jurisdiction, we have no hesitation in holding that High Court had erred in undertaking such an exercise of issuing direction and getting the age of victim examined in the application seeking grant of bail. So here the Supreme Court stated that the High Court's direction are ultra vires. The High Court was not having the power to grant or to give this direction with respect to age determination test in the at the commencement of the investigation, where the High Court stated that you have to do age determination of the victim before the starting of investigation. So this direction is wrong because the High Court does not have such jurisdiction under section 439 of CRPC. Okay, it is well settled that person should be under the age of 18. Why we are discussing this all things? Because we are saying because the person, or because the victim is if the victim is under the age of 18, then we would be applying the POSCO law. So it is well settled that the person should be under the age of 18 to get the protection of POSCO. Therefore, the determination of age of victim is sine qua non. Why this is sine qua non? If you want to apply POSCO Act, you should be stating that the victim is below 18 years. This is a prior condition for application of POSCO. And how the age of victim is to determine was clarified in Jarnail Singh versus State of Haryana 2013 Supreme Court. This is also a landmark case. As we discussed, section 94 discusses there can be a procedure laid down. There is a procedure laid down with respect to age determination, but that is with respect to child in conflict with law or child in need of care and protection. But with respect to victims of POSCO offences, it is not explicitly stating that it would be applicable on them. So here, in the case of Jarnail Singh versus State of Haryana, wherein the Supreme Court held that there is hardly any difference insofar as the issue of minority is concerned between child in conflict with law, means if the accused is a minor, and a child who is a victim of crime. So if there is a question of age determination, it does not matter if the child is accused or the child is victim. The age determination test can be the same. Therefore, it would be just and appropriate to apply Rule 12 of the Juvenile Justice Care and Protection Rules of 2007 to determine age of prosecutrix, that is the victim. Rule 12 of 2007 rules, it must be noted, provided the same hierarchy of documents as has been provided by section 94 of Juvenile Justice Act. As we discussed, first 10th mark sheet, and if it is not available, the birth certificate, and then if it is both are not available, then we would be going for ossification test. So this is the procedure laid down for child in conflict with law. The same procedure would be used for age determination of a child who is a victim of POSCO offences. Now, as High Court stated that this age determination should be conducted by the police officer at the commencement of investigation. So here the question is, at what stage this medical examination with respect to age determination should be conducted. We are saying that the same procedure should be applied. So first we would be seeing the 10th mark sheet, then the birth certificate, then the ossification test or other medical examination. So at what stage you have to do this? So the forum and stage at which the determination of stage is to be made. According to the High Court, the bail court would, if a challenge is presented by the offender. So the High Court stated that even in the bail proceedings, it can be it can be discussed or it can be decided the age of the victim. So the question of age of the victim can also be decided at the stage of bail proceeding, was stated by the High Court. If it has been challenged by the offender, entertain such challenge and take a prima facie view. Here it becomes important to appreciate the difference between the Juvenile Justice Act and the POSCO Act. The juvenile justice is primarily focusing on dealing with child in conflict with law or children in conflict with law, means the person who is a child and he has been considered accused, he has committed certain offenses, but the age of such accused is below 18 years, and children in need of care and protection. So this two specific categories have been provided under the Juvenile Justice Act, that is the children in conflict with law and children in need of care and protection, rather than victims of offences who are minors. So the Juvenile Justice Act is not specifically providing with respect to victims who are minors. It is, however, imperative to recognize that neither of this statutory classification, the child in conflict with law or the child in need of care and protection, expressly includes within its ambit the category of child victim. So these categories are not directly including child victims unless such victims independently satisfy the definitional parameters of vulnerability abandonment. As we know that here child in need of care and protection, a list has been provided ki who would be considered child in need of care and protection, but that too it can be abandoned, surrendered, or suppose the person who is found begging, or suppose who has no person to take care of him. So all would be considered here child in need of care and protection. But in this list there is no specific mention of child victims. They fall outside the direct purview of this classification. If the POSCO Act is examined, it can be found that the Act does not prescribe a manner for determining the age of victim. As discussed right now, the POSCO Act does not provide for age determination of victim, and it is established position in law that procedure under Section 94 of Juvenile Justice is to be applied. There is no determination of age by Juvenile Justice Board like body when it comes to victim. With respect to victims, child in conflict with law, there is a procedure laid down the Juvenile Justice Board would be deciding its age. But with respect to the child victim, there is no procedure laid down in POSCO or in Juvenile Justice Act. If there is a question about the age, it has to be dealt with by the court as per the procedure under Section 94. As discussed right now in journal, saying the same procedure as provided in Section 94 would be used for the age determination of victim. But at which stage you would be using Section 94? At the stage of inquiry, at the stage of trial, at what stage? It is when the court is undertaking the exercise of determination that the defense of accused can challenge the veracity of these documents. Suppose we are saying that I am suppose a person is a child victim and he is claiming that he is below 18 years of age, so he would be showing his 10th mark sheet, and if 10th mark sheet is not there, he would be showing, or she would be showing his birth certificate. So at what stage it should be given? So if I am showing, suppose a child is there and he's showing his 10th mark sheet, you see the age, the birth date written here, and if age is counted on the basis of this date, I am a minor, I am a child. So the opposite party, the defense, would be claiming that this document is false. There is certain challenges with respect to the veracity of the document, that this document is false, this is fabricated, this is fraud, this has been made by fraud. So all this would be alleged by the defense. Since the presumption under this section is rebuttable, as is obvious, and as we have observed, the victim being a child is sine qua non for the application of POSCO. If a charge sheet is filed and it comes charges and it contains charges against a person under POSCO Act, it is but obvious that such an accused would challenge the same at first available instance in the court concerned, and or in other words at the inception of trial. when the matter would be before the court, when the trial is starting, he would be first challenging this point that the victim is not a child. Because if we are saying that if the victim is a child, POSCO would be applicable, and if POSCO would be applicable, there would be a different procedure, and the normal procedure would not be taking place. So therefore, at the first instance only, the defense or the accused would be claiming that this victim is not a child. So this is at the inception of the trial that he would be challenging this point, so as to ensure that the foundation of the trial is correctly in place before it proceeds further. The court would then undertake the exercise as provided for in the accordance with the result obtained therefrom. प्रोसीड फर्दर कि सबसे पहले कोर्ट ट्रायल शुरू होने से पहले क्या करेगा कि इफ इट हैज बीन कंटेस्टेड बाय द अक्यूज दैट द विक्टिम वाज नॉट अ चाइल्ड, हियर द पॉस्को शुड नॉट बीन अप्लाइड, सो द कोर्ट हैज टू बिफोर द कमेंसमेंट ऑफ द ट्रायल वुड बी डिसाइडिंग दिस क्वेश्चन कि व्हाट इज द एज ऑफ द विक्टिम, either under the POSCO Act or under the provision of IPC as the case may be. Should the accused be dissatisfied with the manner in which the result has been drawn by the trial court, an appeal from such determination would have to be filed, and only when the question of age is set at rest can the trial proceed forward on firm footing. Ki if the person, ki suppose the trial court decided that the person victim is not a child, the victim has shown his 10th certificate, but here the contention has been raised by the accused that this document is false. Therefore, the trial court conducted inquiry with respect to this, and here the trial court concluded that the victim is not a child, and therefore normal proceedings should be taking place. So with respect to this, the victim can challenge this, can appeal with respect to this order. So here, after settling the age of the victim, then the trial would be proceeding. So it is very much important to know the age of the victim before the starting of the trial only. Unlike an offender who has claimed benefit of juvenility at any point of time, even after the completion of proceedings, given the benefit of the nature of Juvenile Justice Act. Under Juvenile Justice Acts, we provide that if the person was below the age of 18 at the time of commission of offense, he would be considered child in conflict with law. So he can raise this issue, he can raise this allegation, or he can contest this point that he was a minor, he was a child at the time of commission of offense anytime. So he can raise this argument of his being a child at the time of commission of offense at any point of time of the trial or even after the judgment. A victim of a crime cannot claim to be a juvenile at any point in time for the charges against which an offender is tried. So the same criteria or the same scenario cannot be with respect to victim at any stage, or victim at any stage of the trial or at any stage of inquiry or proceedings cannot claim that he or she was a juvenile, because it has to be decided at the starting of the trial only, because the trial would be dependent on this fact whether the victim is a child or not. So these are intrinsically tied to the age of victim. If a victim of sexual offense was allowed to claim juvenility at any stage of the proceeding in the same manner that an offender can under section 9 of the Juvenile Justice Act, it would have serious procedural and substantive consequences. The consideration of the document enumerated under section 94 is a matter of consideration of evidence. Why we are saying that section 94 is majorly talking about evidences, because the person would be giving the documents and this would be challenged by the another person. So it has to be decided whether this document is true or not. So this is part of evidence, since it may involve examination of witness to prove the veracity of the document. That can only be done by the trial court. So who can decide this, whether the document submitted by the person with respect to his or her age is true or correct or not? This can only be decided by the trial court. Contra evidence to challenge the documents can also be presented only before the trial court. What is the difference between trial court and the court hearing the bail application? Because here we are saying that trial court trial court means where the trial has commenced, and during the bail proceedings that court was only having the jurisdiction to decide the bail application. So here during the bail application you cannot take evidences, it can only be taken before the trial court when the trial has commenced. So here therefore the High Court fell in error in holding that the court in bail jurisdiction is empowered to entertain a challenge to the documents under section 94, which would not apply at the bail stage. So here we are saying that because section 94 discusses with respect to documents which has to be proved by the parties and against which certain evidences or witnesses can be claimed, opposition can be taken. So therefore we are saying that this all things should be conducted by the trial court while trial has commenced, and it should not be the power of a bail court or the court which is entertaining only the bail application. So now next is with respect to, so Supreme Court decided with respect to jurisdiction that the High Court don't have jurisdiction to give such direction. Secondly, the Supreme Court stated that this age determination should be done by the trial court and should not be ordered by the bail application court, the court which is deciding the bail application. Now the third point is medically determining the age of victim. It is clearly held that determination of age of victim is a matter of trial and not at the stage of bail. We have discussed this, that you cannot if the court is hearing bail application, it cannot order the age determination. If the age is under question, the bail court may examine the documents produced to establish age, but it will not enter into the question of those documents being correct or not so. So before the bail court, the court which is hearing the bail application, there also the party would be saying that I am a minor or I am a child, and another party would be challenging this point that this is not a victim, this is not a child victim. So if this is the question before the bail court, so the court would only be seeing the documents produced and it would not be going into the evidences. It won't be checking whether this document is true or not. It would only be seeing the documents on the prima facie basis. The mandate of section 94 is clear. The document provided therein are to be utilized for determination of age of the victim, and only in the absence thereof will medical evidence be resorted. So here the question was, when the High Court directed that before the starting of investigation, police officer has to conduct medical examination for age determination. So is the police officer bound to do medical examination for age determination? So here the Supreme Court stated that with respect to medical examination, we are saying under section 94 we have provided a procedure that first you have to see the 10th mark sheet, then if it is not possible, then you have to see the birth certificate given by the municipal corporation, and if both the things are not there, both the documents are not there, then you would be conducting the medical examination, or then you would be conducting the ossification test. So here this direction that the medical examination should be conducted at the starting of the investigation, this was challenged before the Supreme Court. So it is clear that you can only conduct medical examination only after you don't have the documents which are laid down in section 94. The mandate of section 94 is clear. The documents provided therein are to be utilized for determination of the age of the victim, and only in the absence thereof will medical evidence be resorted. The medical determination of age of the victim cannot be resorted to as a matter of course, much less mandated. So here, as the High Court mandated the police officer to do medical examination at the starting of the investigation, this is wrong, because section 94 provides that first you have to see the documents, and in the absence of these documents, then only you can go for medical examination for age determination. So this mandate as laid down by the High Court is wrong. It can only be employed in a given circumstance where the other stipulation of 94 of Juvenile Justice Act are not or cannot be made. Therefore, the direction of High Court to mandate medical examination is set aside. So all the directions of High Court have been set aside by the Supreme Court. And next, the important, you would have seen this in news ki there is a direction by the Supreme Court, or advice has been given by the Supreme Court with respect to Romeo Juliet clause. What is this Romeo Juliet clause? Ki you would have seen ki many persons or many childs who are in the adolescent stage, and if they are voluntarily, suppose the child, suppose the person, suppose a male child is of 17 years and the girl child is also of 16 or 17 years, so they both are child. Here still, if they are entering into voluntary sexual intercourse or they are having any type of relationship, and if any case has been initiated against the boy that this person has done some sexual offenses against a girl child who is under the age of 18, and POSCO should be applied here. So here the advisory has been given by the Supreme Court that the legislature should consider this adolescent person who are entering into voluntary relationship. On a few occasions, concerns have been expressed by the court with respect to the application of the act. POSCO Act has been applied on consenting adolescents when it comes to consensual relationship between teenagers. Even if the teenagers have involved themselves in consensual sexual activity, still the boy child has been implicated under POSCO Act. Considering the fact that repeated judicial notice has been taken of the misuse of this law, let a copy of the judgment be circulated to the secretary. So here the Supreme Court is stating that this has been advised many times, still we are advising the legislature to consider this thing. Government of India to consider initiation of steps as may be possible to curb this menace, inter alia the introduction of Romeo Juliet clause exempting genuine adolescent relationship from the stronghold of this law. So here the Supreme Court has asked the legislature that you should be considering this situation, and here certain exceptions should be created in the POSCO Act, enacting a mechanism enabling the prosecution of those persons who by the use of this law seek to settle scores. So if you would have seen a picture, the name of the picture or the movie is The Court. It is available on Netflix. The same incidents has been showcased in that movie ki a person, two individuals below the age of 18 has been involved in a romantic relation. Still the boy has been accused of POSCO offenses. So this matter was discussed by the Supreme Court, and advisory has been given by the Supreme Court to the legislature to consider this and make certain laws for the protection of these individuals. So this was the case of today. I hope it was helpful to you. Thank you everyone.